Hello everyone, welcome back again to my channel. Before watching this video, don't forget to like, comment, and subscribe. Now let's start this video. The equation of the justice for fishermen, the urgency to protect fishermen and marine resources in Indonesia. The main function of maritime law are formulated the issues of the ESCAP of or Economic and Social Commission for Asia and the Pacific. Bangkok Guidelines for Maritime Legislation. First, maritime law provides the legal framework for maritime transport. In example, the carrying out of a state's foreign trade. Second, maritime law implements the basic objectives of a state as a port state and coastal state. Third, maritime law may serve the achievement of certain economic purposes, while in other parts, the law of the sea can be interpreted as an aspect regarding the use and sources of marine resources. In the ESCAP Guidelines for Maritime Legislation, it is formulated that the law of the sea encompasses all aspects of the use and resources of oceans. The maritime law constitutes that specialized branch of the law which governs maritime transport and seaborne international trade. Since the birth of the United Nations International Convention on the Law of the Sea or United Nations Convention on the Law of the Sea in 1958 and in 1982, the framework for regulating international sea law covers the following matters. First, the spatial boundaries of all marine species and legal regimes concerning national sovereignty or jurisdiction over oceanic spatial areas which connect to the coast, access to the ocean. Second, shipping, protections, and preservation of the environment against pollution. Third, exploitation of biological and vegetable resources and their preservation, scientific research on maritime. 4. Seabed mining. 5. Settlement of disputed. The Sea Law Convention also details various legal regimes regarding freedom of sailing in the open sea, including in the exclusive economic zone and for seagoing in territorial seas through international straits and archipelago waters. In this arrangement, the coastal state has the authority to make laws and regulations regarding sea traffic in the area for shipping safety and regulate shipping traffic, protect facilities and navigation aids, preserve the environment and control pollution. On February 25, 1992, the Government of the People's Republic of China or PRC announced the law of the territorial sea and its additional zone where the Natuna Island were included in its territorial jurisdiction. China's interest in the South China Sea region extend to the fisheries area of the Natuna Island. This is evident from the capture of KM Kwai Fei with the Chinese flag and 8 crew members from the Bamboo Curtain country by the Indonesian Ministry of Maritime Affairs and Fisheries or KKP. This polemic was exacerbated when the ships did not merely enter Indonesian sovereignty but also illegally caught fish with the protection of a coast guard. The prosecution of illegal fishing in Indonesia. Territorial sovereignty of a country includes 3 dimensions, namely land, air, and sea. Sovereignty over land includes land surface land and also hand under land to an unlimited depth. Sovereignty also airspace includes airspace which is located above the surface of the land area and which is located above the territorial waters of a country. Whereas in the sea area, a country's territorial sovereignty includes the zone on inland, the zone of inland waters, territorial waters, and territorial seas. The territorial sovereignty of a country is also regulated in Article 2 of UN Clause 1982. The explanation of the conventions explain that the basic concept of space for the sovereignty as the highest authority of a state is limited by the territory of that, so that the state has the highest power within its territory. Mokhtar Kusuma Atmaja states that a consequence of understanding sovereignty in this limited sense, besides independence, also understood equality. That is, beside the sovereign states, each of them is independent, they are also of the same rank as the others. Mokhtar Kusuma Atmaja states that independence and equality are forms of the realization and implementation of the definition of sovereignty in a reasonable sense. The importance of sea areas in relation between nations also makes the importance of international sea law important. The purpose of this law is to regulate the dual use of the sea as a highway and as a source of wealth and energy. In addition, the law of the sea also regulates competition between countries in seeking and using the wealth provided by the sea, especially between developed and developing countries. But this regulation is not enough to process the prosecution in illegal fishing. The administration of fisheries courts is included in law enforcement in the field of special courts as regulated in Law Number 45 of 2009 concerning amendments to Law Number 31 of 2004 concerning fisheries. This law instructs the establishment of a fishery court which has the authority to examine, try, and decide criminal acts in the field of fisheries that are within the general court in accordance with the jurisdiction of the district court concerned. Problems of overfishing, physical degradation of coastal habitats, illegal fishing, and illegal disposal of waste are still rampant at this time. The government considers that the previous fisheries law has not been able to anticipate technological developments and legal needs in the fisheries sector. The government that strengthened maritime economic development by promulgating a new fisheries law. The government also emphasized strengthening law enforcement in the field of fisheries and a clear mechanism for monitoring fisheries use. Some of the weaknesses that can be seen in the fisheries law are: the first weakness is the safeguarding of establishing fisheries courts. This got the public spotlight. Criminal law expert Idrianto Seno Aji has criticized the establishment of a fishery court, who believes that the formation of a special court will only cause confusion and inconsistency on the principle of unification and violate the systematization of judicial institutions that recognize the Supreme Court as top judicial. Apart from the regulation and implementation of investigations, there are no provisions regulating the coordination mechanism between investigating agencies. However, the information of fisheries court is basically based on the spirit of overcoming the crisis of the powerlessness of the existing judicial institution in addressing various legal issues related to law enforcement violations in the fisheries sector. This can be seen as the Special Criminal Law number 271 PID SUS 2017 PTPBR. In the judge's consideration part, there are some points that state there is too much court in Indonesia. Thus to do so about the illegal fishing, it had to be done in fisheries court that is not familiar to the offender. The second weakness is the overlapping authority within the institution that handle fisheries violation and crimes. In the context of law enforcement in the field of fisheries, there are several institutions that have the authority to deal the law violations in the Indonesian sea territory, whose authority still overlaps with one another. Some of these institutions include the Indonesian Navy, the Ministry of Marine Affairs and Fisheries, the police, the Directorate General of Immigration, the Directorate General of Customs and Excise, the Attorney General's Office, the Directorate General of Sea Transportation, and the Ministry of Forestry. Okay everyone, this article today. Thank you so much for watching this video. Until the next one. Bye bye.